fresh concerns for Tommy Robinson that he might be charged with contempt of court again upon release from prison if he fails to remove the videos silenced. Now, I've got a few thoughts on this. They cannot obviously amount to legal advice for him or for anybody else for that matter, but I do have a few thoughts on it. But I saw this post from their admin team where they say that they've learned that the Attorney General plans to charge him with contempt again upon release from prison, facing another 2 years in prison. Either the film's removed, they say, or he'll be left to rot in a cycle of imprisonment without a jury. He's defenseless against this lawfare, they say. Now, the risk here is that there is obviously an ongoing injunction, which I've spoken about in previous videos, not to repeat the defamatory allegations. Now, this gives rise to a whole discussion of free speech. What is or is not free speech? This video of mine here is in two halves. The second half is a big win for free speech, so more about that in the second half of the video. Please, first of all, do subscribe to my channel if you like these brutally honest updates. I like to keep you informed with what my views are. They're not always going to be right, but I will do my best and I'll read these things and let you know what I think. Now, there is a real risk here for Tommy Robinson because, as I say, this is an ongoing injunction and is the court saying that you must not do this. Now, whilst in the UK we do have double jeopardy rules, meaning broadly that you cannot be prosecuted for the same crime twice. This is not quite the same thing because this is contempt of court. Contempt of court is not the same as a criminal offence, even though the court dealt with the sanction on the same basis as other criminal offences. This is not quite the same thing. This is an ongoing injunction where the court has ordered not to repeat these allegations. Now, the court usually will look not to punish somebody for the same thing twice. Even if it's an ongoing thing, the courts tend to try to avoid punishing somebody for the same thing twice. So there would usually have to be some kind of fresh activity, be that a comment, be that a share, be that more views, be that it gets more attention somewhere else, or just something that sparks fresh action and a fresh allegation that could be brought against him. You remember from the original 2 contempt applications that he was accused of breaching this injunction on 10 separate occasions. He admitted breaching the injunction on the occasions and in the manner alleged. So there's very real risk here because the court does have a very broad power in respect of contempt. Or the Attorney General might see it that this is an ongoing contempt and thus warrants coming back to court. Now, there is a hint at this in the original judgment here under punitive and coercive elements. The court said it's appropriate to divide the sanction into punitive and coercive elements. Punitive being the punishment bit and coercive being to try to persuade him to comply. The period is 14 months, less 3 days, as we've discussed before. The balance of 4 months is the coercive element. That means the court said that it is open to him to purge his contempt and seek the remittal of this 4 months. I've discussed this before. In order to do that, he'd need to demonstrate a commitment to comply with the injunction. That is likely to require, the court said, at the least, the removal of silenced from social media accounts, and its removal and removal of the other publications that breach the injunction from the other online providers, or at least taking all reasonable steps to secure their removal. But there's an even bigger hint in the paragraph above, the final bit here, where it says he will continue to be subject to the injunction and liable to sanction for contempt of court if he breaches the injunction. Now, what it doesn't say is if the breach is an ongoing one. What it does mean quite clearly is if that there is a further breach or another breach, a separate breach, that it will be liable to sanction because this is an ongoing injunction and he remains to be bound by this injunction. But as I say, an ongoing injunction, albeit he's been punished for it, and we tend to avoid punishing people twice, it is not out of the question that the Attorney General might bring this back to court and the court might look at this again. Remembering, of course, that failing to do something can itself be a breach of an injunction. So that could be argued as a fresh contempt. So all of this flies in the face, really, of what some people think is free speech. Now, I've talked about whether or not this is the exercise of free speech or not and how that overlaps with the law of defamation and thus complying with injunctions where you've been prevented from repeating defamatory allegations. But there is, as I said, a big case as a win for free speech coming up in the next bit of the video. But before the second half of the video, a bit of a segue and a bit of a story. Take a listen to this. Now, just a moment, I want to show you something from my personal email inbox. Now, I don't normally show people my inbox, but this is so important. It's such a serious scam that I really want to show it to you. So this is targeting YouTube creators, but there's another version that is targeting general members of the public and Google users and so on. So this is my inbox. This is an email that genuinely came from YouTube. And it says, YouTube Creators has shared a private video with you on YouTube. Now, as a YouTube creator, I know that there is a channel called YouTube Creators and that there are other channels that are genuinely affiliated with YouTube. And when this says that someone shared a private video with me, I think, maybe that's of interest. I mean, I don't, because I can see a scam a mile away, which is why I'm showing it to you on this video. Now, you can see in the top here, it's genuinely come from YouTube. And if I hit reply, it's genuinely replying to YouTube. And this is a real video that's sent from a real account, a real channel, and it's shared with me. And what it does is go through to a YouTube channel with a YouTube video with a deep fake of the CEO of YouTube, and it talks to me and tells me to click on a link in the description below, which then takes me off to a nefarious website. Now, the reason I'm telling you this and showing you this is because this is the very reason that I support and I wholeheartedly recommend NordVPN on this channel. Now, this is not just a run-of-the-mill advert that I'm slamming into the video here. This genuinely saved me because initially, whilst I did sort of suspect that this was a scam, when I went through to it, NordVPN does flag up these kind of links to show that they are malicious links, malicious downloads, and you shouldn't go any further. So if you are in any doubt that either you or members of your family may just slip into this, what this can do is they can hijack your session, meaning it gives them access to everything in your current browser. That's your emails, maybe your banks, maybe your YouTube channels and accounts and things like that. It can potentially give them full access to everything you're logged into if they steal the session. It's called session hijacking. But NordVPN will prevent them from doing that with the detection for malicious links, malicious downloads, and all of that sort of stuff. And not only that, it gives you a virtual IP address. It keeps all of your browsing and everything anonymous. They don't keep any logs, and there are all sorts of other ways that they keep you safe. But this is one that really jumped out to me, that NordVPN will genuinely help people. And of course, that is why I partner with them on my channel. And as a partner, I get you 4 months extra free on top of any existing deal, along with their 30-day money-back guarantee if you change your mind. But you won't, because once you see how many things that it blocks and prevents you from being scammed by, this is well worth having, and the 4 months extra free you get with my link in the description below. So it's nordvpn.com/BBB. It's on screen. It's in the description below. Go and sign up. It's cheaper than a cup of coffee. You get 4 months free with my link. There's nothing to lose. It is absolute peace of mind. And this email here is exactly why you need to sign up for NordVPN. Take it from me, this will save you from disaster. The link's below, and thanks to Nord for sponsoring this video. So now let's take a look at what can really only be described as a big win for free speech. The High Court has recently handed down a ruling which demonstrates just how wrongly some police services have responded and acted in relation to social media posts by doorstepping people, questioning people, even arresting and detaining people over comments they've made online. But this ruling also demonstrates how Greater Manchester Police got it right on this occasion. Moreover, the High Court made it absolutely clear that it was not, as a matter of fact, the role of the police to investigate every comment on social media. Rather, it is their role only to investigate those comments which might involve the commission of criminal offences. And there's more about that in this video, and that was a direct quote a near direct quote from this judgment. So what are we talking about? Well, it's a little bit of a sensitive nature for this video, so I won't go into every single detail because YouTube doesn't tend to like that, but I will give you enough of it so that you can understand what's going on. This essentially was a complaint over social media posts on X. It involved posts by one user who was an interested party to this claim. More about the parties in a moment to explain that. Whose views were described by counsel as gender critical or biological realist, in that he believed that sex is biological, immutable, and binary, and considers the concept of gender identity and gender self-identification are inherently oppressive constructs. But he also accepted that this style of writing used on X was abrasive. Now, as to the parties, the claimant in this case was a trans woman. Now, this complaint was made to the police about posts by this interested party. So I'll explain the parties here. So the claim for judicial review was brought here against Greater Manchester Police for their ultimate decision not to prosecute in respect of a series of posts that the claimant in this case thought crossed the criminal threshold, should be criminal offences, and that he should be held criminally accountable. Now, the posts by and large referred to in this claim related to the murder of Brianna Gray. Now, that was obviously a terrible and tragic story that did attract a lot of media attention. Now, one of the reasons this caused a bit of a storm with posts on X and elsewhere, because some people believed and said online that it was being used for political purposes to further their political agenda and so on, which many people believe was the wrong thing to do. And so here's an example of those posts. I will substitute some words for the sake of YouTube, but you'll get the idea. Now, the court noted here, it's the highlighted sections on the screen here, the court noted that it was suggested at an early stage that this M was hate-related. And the user commented as follows: "These disgusting ghouls are so excited that a trans person has finally been M'd in the UK, that they use it to attack J.K. Rowling and TERFs, that they can't bring themselves to wait even a day for the facts." And so the obvious implication by that post there was that some people were nefariously using this tragic event to further their objectives, their views, maybe their political goals or whatever, and suggesting that they were using this story to attack people. TERFs, by the way, is someone who is seen to be critical of trans people or hold gender-critical beliefs and so on, and suggesting that they weren't waiting for the facts of this case before making those comments. And these posts then even went on to criticise some nice comments made by MPs about Brianna Gray, saying, "How the F would you know, you ghoul?" So again, suggesting that some people were using this story to promote their views or their political career and so on. The posts then went on to persistently correct other people when they referred to Brianna Gray as female, correcting people to say that Brianna was male, a trans-identifying boy, human beings can't change sex, he was a boy, human beings can't change sex, etc. These posts went on and on. Now, forgive me if some people find those upsetting. This is not the intention of the video. The intention of the video here is to run through what the court said in the challenge to the police decision to no further action this complaint. So the police were asked to investigate and prosecute these offences under the Malicious Communications Act. More about that in a moment and what may or may not cross the threshold. But a lot of people are genuinely worried about what you can say online, whether you can be critical online, whether you can be insulting online, say things that other people find offensive online, and so on. This case, as horrible as many of you may find those posts, this case does highlight that these do not cross the criminal threshold. Just because some people find them upsetting and don't like to read those, that doesn't necessarily make them criminal. So the claimant in this case, after reporting it to the police opened up a crime report. The defendant, that's Greater Manchester Police, proceeded to consider whether any criminal offences had been committed and whether they should refer the matter to the CPS for a charging decision. Their primary focus was whether the offence of sending electronic communications with intent to cause distress or anxiety contrary to the Malicious Communications Act 1988, Section 1, had been committed. In around June 2023, the police concluded that this was not the case, and they decided to close the investigation. The police then sent out an email to the claimant in this case, the complainant in the original complaint, to confirm this, but it seems for one reason or another that was not received. The claimant then contacted the police to say the 6-month time limit for commencing a prosecution for a summary-only offence had passed, and that the poster was still, quote, engaged in pretty much a full-time course of conduct and harassment. The claimant was then told that there was no further investigation and that all of these posts were considered under the realms of hate incidents and not crimes. More about that in a moment, because that is somewhat alarming. More about that in a minute. The claimant then was unhappy with the decision, and there was further correspondence between them and so on. And eventually the rationale was provided that whilst distressing, these did not reach the threshold for the criminal offence that was being reported. Now, the court then goes on to look at the legal framework, and predominantly, obviously, the offence of sending letters with intent to cause distress and anxiety. The court summarised the Article 10 right: everyone has the right to the freedom of expression. This right shall include the freedom to hold opinions and receive and impart information and ideas without interference of public authority, regardless of frontiers, etc. And the case law says that it must be grossly offensive. It is insufficient if the message was just in bad taste or even shockingly bad taste. So you can make a post that is shockingly bad taste and someone can find that offensive, but unless it is grossly offensive, it will not cross that threshold. Now, there are some examples which I shall not read out of what might cross that threshold here. And there are several other cases, Connolly in the DPP, Scotto in the CPS, all of which seeking to address what comments could possibly cross this criminal threshold. Now, there is some guidance on this, and it is a question of fact. The court said as much here. It's referencing the case law and says whether a message is grossly offensive is a question of fact to be answered objectively by reference to its contents and context, not its actual effect. So not whether somebody found it offensive, etc., but the contents of that message, the context in which it was sent, and whether or not, as a question of fact, it is grossly offensive. Drawing on and referencing the case law, the court then noted as follows. The judge drew on the following points from this evidence. First, there is a rigorous ongoing debate about trans rights. Professor Stock, from one of the previous cases, evidence shows that some involved in the debate are readily willing to label those with different viewpoints as transphobic, or are displaying hatred when they're not. It is clear that there are those on one side of the debate who simply will not tolerate the views even when they're expressed by legitimate scholars whose views are not grounded in hate or bigotry or prejudice or hostility, but are based on legitimately different value judgments, reasoning and analysis, and form part of mainstream academic research. So in other words, if you make a legitimate comment on something, there are, the court acknowledges, some people that just label that as transphobic and hate, regardless of the merits of the underlying comment. The court then goes on to say the judge was clear that those tweets were protected by the claimant's Article 10 right to the freedom of expression. The court then went on to discuss the merits of this particular case, and so you can pause it, screenshot it, or I'll try to link the judgment in the description below. But in short, the judge noted what this conversation was about, what the posts were about, and the court said, in my judgment, the contents of the post illustrates that this interested party, the original poster, was doing two things. Firstly, condemning the fact, as he saw it, that this tragic murder of Brianna was being weaponized by activists to attack J.K. Rowling and other campaigners. This was a valid opinion that cannot conceivably be said to meet the grossly offensive threshold, as set out in case law. Second, he was expressing the opinion that gender is biologically determined and cannot be changed, such that it is appropriate to refer to someone by pronouns which match their biological sex, including their death certificate. This is a controversial matter of public interest in which many people share the underlying view of the interested party's tweets. It has been specifically recognized that the interested party's opinion about gender is one that should be tolerated in a democratic society, as well as in Miller, Forstater, Higgs, etc. The claimant in the case argued that the Article 10 freedom of expression was not applicable because this was hate speech. Their overarching position was that the interested party, the original commenters, was such that they contravened the basic standards of society, etc. But the judge said, I cannot accept this submission for the reasons given above. And so for all these reasons, the court said the defendant, the police force, was entitled and correct to conclude that the posts did not cross the criminal threshold to be considered grossly offensive as interpreted by case law. And there were further submissions, but that didn't change the court's mind. The court made comment on the role of social media platforms and so on, but ultimately the court said, accordingly, for all those reasons, the claimant's claim is dismissed. The police decision to take no further action against this poster was both lawful and correct. So, particularly in light, if you have gender critical views, I'm not saying that I condone or I approve of being hostile towards anybody else, but if you make comments that other people perceive to be hostile, but it is part of a legitimate discussion, and even if your posts are in bad taste, or as the court put it here, shockingly bad taste, that does not take them across the criminal threshold. And particularly in light of the recent Supreme Court ruling in For Women Scotland that trans women are men for the purposes of the Equality Act, that is now defined as an authoritative ruling by the Supreme Court that is to be applied in the Equality Act. But nonetheless, there is still much heated debate across all sorts of accounts and platforms about what this should mean, what companies should do, and what should happen next. The only thing I will round off with is that if companies choose to ignore this ruling and they do not uphold single-sex spaces and they allow trans women into women's spaces, for example, and a woman finds a trans woman in the women's toilets, they are very likely now to have a very easy claim against that service provider if they've told them that this is a women's only toilet, bathroom, changing room or facility or whatever. That would be my warning to companies, that it would be a very easy claim to just follow the Supreme Court ruling that this was definitively designated as a single-sex space. So there is heated discussion out there. I would caveat that you look at the examples in this judgment that I didn't read out, but they are in the judgment. They were on screen for a short time of what might be grossly offensive in this context and what is not. So just giving your views, particularly if it is legitimate commentary, discussion, etc. Even if someone perceives that to be hatred, that doesn't make it hatred. Even if they perceive it to be in bad taste or shockingly bad taste or even offensive, the freedom of expression includes the right to offend people with what you say. They might find it offensive. I'm not saying I condone doing things deliberately offensively, but that's another matter. You are free to do so long as it doesn't cross that criminal threshold of being grossly offensive. Please do subscribe to the channel. I am ever grateful to you for doing that. And as always, thank you for watching.